Thank you. The people who see this on record will only hear the second part of the drosh, but I did a wedding in Boston, and on the way back yesterday, I was sitting next to two people that I did not know, and I overheard their conversation. They did not know me. They did not know I was a rabbi. But first, this young woman began to tell her story to the man next to her, and her story was difficult. Her father had passed away. He had been paralyzed for 30 years. And then she said her brother-in-law lost his life at 41 years old by a stray bullet that was hit him while he was in his room. And the man next to us looked at her and said, "I'm a pastor." And for the next 3 hours, they began talking about theology. And I thought, do I say something? Do I not? And I didn't say anything. And I got off the airplane. As I was walking to baggage claim, I heard this pastor tell this young woman, "And if you're serious about going to Israel, call me." And at that point, I said, "You're going to Israel?" He said, "Yes, I'm a pastor." And I said, "Well, I'm a rabbi." And he explained he's a pastor at a large church in Fresno, California. And he had been to Israel 8 times. And I said, we exchanged numbers and we'll hopefully have a chance to connect. I tell that story because Vayisu Vayachanu, we travel and we encamp. And you never know who you are going to encamp with as you travel. And when you engage or when you don't engage. And for 5 hours, I did not engage until I heard the word Israel. I thought, I guess it's time. And we all had those moments that, right, what if I did not engage at that moment? And I did engage. We'll see what happens. And no promises, no guarantees. But the fact that I was, I guess you can say, eavesdropping at first on my vayisu, on my journeys, but vayachanu, thankfully out of that conversation, hopefully we gained a friend. We gained somebody that we can work together with as well. And I'm looking forward to the conversation tonight of how we also can work together to make the journeys that we take in our lives, wherever it is, whether it's college, grad school, wherever we do, knowing that we can learn from these amazing professors this evening. So looking forward to a wonderful evening.
Thank you, Rabbi Sherman. And by the way, this session will be recorded and will be posted to the Sinai YouTube channel. So just want to let everyone know. Let's have Jeff Kitchhaven go forward. And Jeff, please take it forward.
Thank you, Mike, and thank you, Rabbi Sherman. Let's get on with the show. We're very delighted to have as our moderator tonight, Ariel Newman, a loyal member of Sinai Temple, a very distinguished record. He's a graduate, went to college at Columbia University in New York City, where he was student body president, then went on to Harvard Law School, came to Los Angeles, clerked for a federal judge, worked as a federal prosecutor, assistant United States attorney, and now is a partner in the prestigious Bird Morella law firm. There's nobody more qualified. Ariel's also a dad in Sinai Akiva, so that gives him some skin in the game here. Ariel, we're delighted. Welcome to our Men's Club program. The floor is yours.
All right, thanks so much, Jeff. Thanks, Rabbi Sherman. Let's get into it. I'll take a moment to introduce each of our panelists. Thanks to both of them for joining us and taking the time to plan and participate tonight. So first up, Dean Erwin Chemerinsky. Dean Chemerinsky is Dean and Jesse H. Chopper Distinguished Professor of Law at the University of California, Berkeley School of Law. Prior to assuming this position, he was the founding dean of the UC Irvine Law School and a professor at Duke Law School, USC Law School, and DePaul Law School. He's the author of 12 books and over 200 law review articles, frequently argues appellate cases, including in the United States Supreme Court. And as of January 2021, he was named president-elect of the Association of American Law Schools. So Dean Chemerinsky, thank you so much for being here tonight. Professor Richard Sander is the Duke Minier Distinguished Professor of Law at UCLA, and he also holds a doctorate in economics. Professor Sander has published a book and many articles exploring various aspects of how affirmative action policies actually work in practice. He's also a leading authority on the problem of housing segregation and is vice chair of an organization called the Inclusivity Institute that pioneers new techniques to reduce segregation and improve housing affordability. Thank you, Professor Sander, for being here. And if we were in person, I'd ask everybody to applaud, but since we're not, I'll get into it. The format for tonight is as follows. I'll give a very brief introduction just to set the stage and then turn it over to the panelists. I have prepared questions for each of them, but I'm hoping that you will engage with each other. Please take 3 to 4 minutes to answer my questions, another 2 to 4 minutes to respond to what the other person said, and the original answerer should take another minute back. I'll pass it back and forth. And please feel free to pose questions to each other if you think it would be interesting to our audience. And then as Jeff said, towards the end, we will open it up to questions. And now we only have less than an hour on a very complicated subject, but hoping to give everyone real insight and food for thought, and maybe cause you to re-examine some of your preconceived notions, as I did in the course of preparing for this. So just a minute to frame the discussion. We're talking about what's referred to as the Harvard case before the Supreme Court. The case asks the Supreme Court to review Harvard's race-conscious admissions policy for undergraduate students. The plaintiff in the case, which is called Students for Fair Admissions versus President and Fellows of Harvard College, presents its lawsuit as a bid to vindicate the rights of Asian American applicants to Harvard, though it's worth noting that, as I understand it, there's no Asian American who's actually a named plaintiff, meaning somebody bringing the lawsuit. And although Harvard, as we know, rejects the overwhelming majority of applicants that it gets, the rejection rate among Asian Americans is especially high. There's broad agreement in the legal community that the implications of this case go beyond Harvard and beyond people of Asian descent. So with that in mind, I was going to take a minute to lay out the arguments on either side, but let's get into it. Dean Chemerinsky, I'll turn to you first. And our audience is likely composed of lawyers and non-lawyers. Can you just briefly explain why this case is now before the Supreme Court, why this case, as opposed to other cases, made it all the way to the Supreme Court, and how it fits into the history of affirmative action litigation? A lot for 3 or 4 minutes, but I know you can do it.
It's a pleasure to be part of the program. I remember with great fondness the weekend I spent at Sinai Temple. Now, to be clear, this case is not yet before the Supreme Court. There's a petition for Supreme Court review. It's being opposed by Harvard, and the Supreme Court has not yet decided whether to take the case. We'll know that sometime, probably in the fall. In 1978, in Regents University of California versus Berkeley, the Supreme Court 5-4 upheld the ability of college universities to engage in affirmative action. The crucial opinion was written by Justice Lewis Powell, and he said college universities have a compelling interest in having a diverse student body, and college universities can use race as one factor among many in decisions to enhance diversity to benefit minorities. June of 2003, in Grutter versus Bollinger, the majority of the court reaffirmed what Justice Powell had said in Berkeley. Justice O'Connor wrote the opinion for the court here, and she said, diversity in college universities is a compelling interest, that it is permissible for college universities to use race as one factor among many to enhance diversity and benefit minorities. And most recently, in June of 2016, in Fisher versus University of Texas, the Supreme Court reaffirmed that college universities have a compelling interest in diversity and may use race as one factor among many to enhance diversity. Now, what makes the Harvard case a bit different is all the other cases involve government institutions. The Constitution applies to the government. It doesn't apply to private institutions like Harvard. Harvard is being sued under a federal statute, Title VI of the 1964 Civil Rights Act, that says recipients of federal funds can't discriminate on account of race. Now, the Supreme Court has indicated the standards are the same under the Constitution, under Title VI. So it's possible the Supreme Court will take this case and issue a pronouncement To reaffirm what it said before, or to dramatically change the law with regard to affirmative action? The composition of the court has changed since 2016. Justices Kennedy and Ginsburg were in the majority. Kennedy even wrote the opinion in Fisher. They're gone from the court, and we have more conservative justices replacing them. That's, as best as I can, a description of what the court has done. Let me just say a word about why the court has done this. I've been a professor for 41 years. I've taught in classrooms that are almost all white, in classrooms with a significant number of diverse students. The education for all students is different when there's diversity. Diversity matters in the classroom, and it matters in the legal profession. And the reality is, we're not going to have diversity without being able to use race as a factor. The history of discrimination, the current discrimination makes it so. The federal district court judge in the Harvard case said that without affirmative action, the number of Blacks at Harvard would decrease from 14% to 6%. The number of Latinx students would decrease from 14% to 9%. No college or university has ever accepted students just on the basis of test scores, just on the basis of grades. We've always valued diversity. Students from Montana and North Dakota have found it easier to get into Harvard than students from Boston or New York. Students with special skills have always found it easier to get into elite schools. What schools recognize is diversity matters, and racial diversity certainly does.
Professor Sander, I'll give you a few minutes to respond if you would, and just note for the audience that you filed a brief essentially encouraging the Supreme Court to take up this case. So if you can talk about how that fits into to things, that would be helpful.
Sure, thank you. Glad to be here. Thank you for having me. So I think that the Harvard case is distinctive from other ones brought before in affirmative action because it's a heavily empirical case. A lot of the earlier challenges to affirmative action were basically challenging kind of aspects of programs that the defendants admitted existed. So, for example, in the Gratz case, which was also brought in 2003 against the University of Michigan, the challenge was to a policy at the University of Michigan that assigned a certain number of points to students if they were members of underrepresented minorities. So the challenge in that case was to the idea that one can actually set a specific number of points and give that to all minority applicants. In the Bakke case, a lot of the challenge was about whether or not it was permissible for a university to have a quota. So again, you had these sort of legal tests that were the centerpiece of the cases. In the Harvard case, the approach has been very heavily empirical on the plaintiff's part from the beginning. And by the way, the plaintiffs, it's true that they're not sort of public plaintiffs in this case, but Students for Fair Admissions does have something like 20,000 members, and I can tell you from many meetings with Asian American organizations that there's a lot of community-based support and concern about the case and about discrimination against Asian Americans. So the Harvard case, unlike earlier cases, has really made empiricism the center of the case, and the experts for Harvard and for the plaintiffs were kind of the star.
Yep, I get that.
They were kind of the star witnesses at the trial and developed extensive reports based on extensive discovery. One of the key upshots of this empiricism is that it sort of puts a lot of the earlier cases into much more striking relief. So I think a reason why Harvard was sued is that Harvard was very important in the Bakke opinion because, as Dean Chemerinsky noted, the court held that race could be considered as one factor among many, and it cited as a model Harvard's admissions policy, which talked about all the different diversity factors that it took into account. What we see when we look at the empirical data on Harvard admissions is that it's true Harvard takes many factors into account, but race is given a weight that's not given to virtually any other factor, certainly not any other diversity factor. It's given much more weight than socioeconomic disadvantages of students. It's given much more weight than geography, more weight than the sort of area of intellectual interest or intellectual diversity that students bring. So what this case allows one to look at is the relative weight and to see that race is really being given a preeminent spot. It's also, I think, pretty clear from the data that Harvard is extremely concerned about maintaining a very specific racial composition in its class. And there was very compelling evidence brought up by the plaintiffs that showed that Harvard has what I think is a quota policy, where they admit year after year the exact same percentage of students who are Blacks as who are non-Blacks. Well, it's not an advertised quota policy, as was the case at the Davis Medical School in Bucky, but it's in effect works just like a quota. So I think the Harvard case really raises for the Supreme Court's consideration the issues of whether empirical facts matter, whether we're going to actually look at how policies operate in practice in deciding what's acceptable in principle.
Thank you, Professor Sander. I don't know, Dean Chemerinsky, if you have anything in response for a minute or two.
Sure. Professor Sander is right that this case does turn on the facts. But what Professor Sander omits is that the district court did extensive fact finding. And while Professor Sander offers his view of the facts, that's not the facts that are before the Supreme Court. When a case is on appeal in a court of appeals or on the Supreme Court, the higher courts are bound by the fact finding by the district court. The district court expressly rejected the idea that this is a racial quota in any way, or that there's any form of set aside for minority students. Now, Professor Sander can characterize it that way all he wants, but there's a fact finding by the district court to the contrary that's binding on the Supreme Court. Professor Sander says that race is the decisive factor, more important than any other factor. Again, that's not what the district court found here. And so I think what we've got to do is focus on the facts as found by the district court, because those are the facts that are binding on the Supreme Court. And it may very well be that because this case is so fact intensive, the Supreme Court isn't going to see this as the right vehicle for reconsidering affirmative action. Also, Professor Sander presents this as Asian Americans are united against affirmative action. That's simply nonsense. The Asian American community is very split. If you look at the briefs that were filed in the Court of Appeals, there were certainly as many briefs for Asian American groups supporting affirmative action as those opposing affirmative action. The effects of affirmative action on Asians are far more uncertain and far less clear at disadvantages of Asian Americans than Professor Sander wants to assume.
Okay, and Professor Sander, I'll give you next question is to you, and if you want to take a minute to respond as well, I think it'll fit together. Okay.
Okay, that's fine.
The question is, as I look at your work and when we spoke, I take it that you generally approach this issue from an empirical perspective, and you're looking at the results in many ways of race-conscious admissions policies. But you're also obviously a legal scholar, and like I said, you've submitted a legal brief to the Supreme Court on this particular case. Can you talk to our audience, explain in briefly what your mismatch theory is and how it fits into the legal framework that the Supreme Court might consider if it does take this case?
Sure. I'll just briefly respond.
Yeah, sure. Go ahead.
And then the 2 points he raises are that the Supreme Court is bound by the district court's interpretation of the facts. I don't think that's true where the higher court finds the lower court to be clearly erroneous. And what's striking about the district court opinion is how much of the plaintiff's case was simply ignored. There was absolutely no discussion of the quota evidence that I'm talking about. So if the factual presentation of the case doesn't really depend on the credibility of the witnesses, but depends on the written record, which is fully available to the court, and the district court simply ignores, never even discusses, huge swaths of the empirical record, then I think the facts are before the Supreme Court. Secondly, I didn't say, as Dean Chemerinsky claimed, that all Asian Americans are on the side of Students for Fair Admissions. I said that there's a lot of community support for this. And again, what's striking here is that if you ask people how they feel about affirmative action as a concept, majority of people are pretty supportive. If you ask them how they feel about racial preferences and race being given actual substantial weight in the admissions process, support levels dry up dramatically. And we saw that in California last year with the debate over Prop 16. Prop 16 was going to repeal Prop 209 and allow schools and other government agencies to use racial preferences again. And it was pretty decisively rejected. And the vote was much less racially polarized than it was in 1996 when Prop 209 was adopted. So I think there's actually not much public support for the kind of practices that Harvard has been demonstrated to be engaged in. Okay, so to get to your question, Ariel, the idea of mismatch is that and a key reason why I think affirmative action is problematic when it takes the form of racial preferences and admissions is that it creates inequality in schools. The original idea, as Dean Chemerinsky said, was that by having race as one of the factors that we consider, we create this sort of robust diversity of environment in the school. But when you're using very large preferences to create that diversity, then you actually set up this situation where it's kind of bad from all the things that we want to achieve. For example, in law schools, at a typical American law school that uses large preferences, African Americans end up having grades that are very heavily clustered in the bottom of their classes. About half the Black students end up at the bottom 10th of their law classes. At the undergraduate level, it's not quite as severe, but it's still pretty bad. Well, when that happens, there are several things ensue. One is that you're creating an environment where it's very easy for the minority students who receive the preferences to feel insecure and to feel as though racism is operating in the school because they see themselves and other peers of the same race as getting bad grades. And you know, a logical explanation of that is the school is singling me out for bad treatment. It creates an environment where students in general can form negative stereotypes because they're seeing students who are in racial minorities struggling academically in class. And those things in turn sort of lead to this environment where matters on race are censored. I mean, I've been teaching at a very diverse school, UCLA, for 30 years, and I've been terribly disturbed by the evolution I've seen towards an increasing intolerance of open discussion of many issues, including affirmative action. Students are afraid now to articulate concerns that they have about policies like affirmative action. So you don't get a robust diversity. You get sort of this extremely sifted and narrow, ideologically narrow view of how the issues operate. The specific problem mismatch that I have focused on in my research goes to a related aspect of this, which is that if you use large preferences and students who receive those preferences academically struggle, they will end up having worse outcomes than they would if they went to a school where their credentials were similar to those of their peers. And I'll share my screen to show what I think is a pretty, screen sharing is disabled, it said. We tried this out before, but it doesn't seem to be working, Ariel.
I think I can't share. I can't let you share, but maybe somebody else can.
Oh, all done.
Yeah.
You should
There
be
you
in
go.
now.
Okay. Good, that worked. Okay, can you see this table?
Yes.
So this is a study that we recently did that compares 3 different law schools. One has a pretty high median LSAT, which you can see here. One has a somewhat lower one, and the third has a still lower one. And what this shows is that when you admit students who are about 10 points below the median of the most elite school in terms of their LSAT scores, they have a 39% first-time bar passage rate. If they go to the schools that have lower median LSATs, in other words, schools where they're less mismatched, where their credentials more closely match those of their fellow students, they have much higher bar passage rates. There are many ways to demonstrate this point, and there's a whole raft of peer-reviewed literature now finding this to be a problem in many different parts of undergraduate and graduate education. But it's really a common sense idea that if you use extremely large preferences to admit students, you're often not doing them a favor.
Okay, and I want to, in a minute, move over to sort of how we can think about this as a Jewish community. But Dean Chemerinsky, before I do that, I want to give you an opportunity to answer how do you answer the mismatch theory, and whether outcomes like those being documented by Professor Sanders should even be part of the consideration here by the courts.
Professor Sanders has been arguing mismatch for about 20 years. Study after study has been done that shows that the mismatch hypothesis is wrong. Let me quote to you from a renowned social scientist, Professor Rick Lempert at the University of Michigan, who reviewed these studies, and I quote, "The overwhelming weight of reliable evidence indicates that the academic overmatch, attending a school one's academic credentials are below those of most students, mismatch, has few if any adverse effects on minority students and quite likely enhances their prospects for graduation and job success. Moreover, some studies that proponents of the mismatch hypothesis have relied on are so fundamentally flawed that they offer nothing of value. The empirical evidence does not support assertions that minority students as a group, and African American students in particular, suffer from the academic mismatch when selecting college universities as race is a factor in choosing whom to admit. Conclusion of this effect and analysis of law school performance have been rejected by most social scientists who have examined the data, and key studies are fatally flawed by mistaken assumptions. Only by failing to acknowledge most relevant studies and by making misleading arguments does Sanders manage to give the impression that the mismatch hypothesis has any basis. Well, why is that? Some of it is that statistics like LSAT and grades are very imprecise predictors of how somebody's going to do once in law school. Some of it is that there's an enormous benefit to graduating from a more prestigious school that's not taken into account by the mismatch hypothesis. The study that Professor Sanders just presented has so many mistaken assumptions. A school that has the lower median LSAT is much more likely to intensive bar preparation than the school with the higher LSAT. That doesn't prove mismatch. It simply shows other variables are at work. Finally, Professor Sanders says that there's an intolerance to law schools of opposing viewpoints. He and I would agree on this. I think that there's too much peer pressure to silence one another, but that has absolutely nothing to do with mismatch. I'd love to have a program on how we can encourage more robust debate in colleges and universities. The reality still is that diversity matters in the classroom. It matters for the education of all. And what Professor Sanders never going to deny is without affirmative action, we won't be able to achieve that diversity.
So, Dean Chemerinsky, Ariel?
Yeah, I was saying, do you want to take a minute? Go ahead. I don't want to get too in the weeds here for our non-lawyer audience.
Hang on. Dean Chemerinsky, you extensively quoted from Rick Lempert as refuting mismatch. Has Rick Lempert ever published his findings in a peer-reviewed article?
Rick Lempert has written extensively about this. Law reviews generally are not peer-reviewed, as you know. I don't think that in the context of law schools, we say because an article is not peer-reviewed, it's less reliable. We could go through the study after study, Professor Sanders, that has refuted mismatch, including in peer-reviewed articles.
Actually, there are 0 peer-reviewed articles that have refuted mismatch, and there are about 25 and counting that have confirmed mismatch. There was an extensive review of the law school mismatch hypothesis in the Journal of Economic Literature. It was written by 2 economists of differing viewpoints. It was reviewed by 7 other economists, and it was published as the lead issue for their annual report. There is an abundance of peer-reviewed literature finding this. Whereas what's very striking is that none of the critiques that Dean Chemerinsky is citing have been published in peer-reviewed journals. And law reviews are very often ideologically predisposed to try to say the politically correct thing. Richard Lempert hasn't even managed to publish most of his critiques. I'm not sure that the article that Dean Chemerinsky cited from is even published. So it's really a disgrace. The U.S. Civil Rights Commission held a hearing and published an extensive report saying that there was a lot of evidence to support the mismatch and that schools should evaluate it carefully. Many of repeatedly in these peer-reviewed social science articles, there have been calls for better data about what law schools are actually doing. But the leadership of the Legal Academy, including associations that Dean Chemerinsky has been associated with, have tried to suppress that data. They've fought against the transparency. There has never been a release of the California bar data that I've sought, which would have very clearly shown the patterns so that no one could deny it. The studies that I've had to work on have often used imperfect data or just from a handful of schools. If we had more transparency and better data, then even the most ferocious skeptics, I think, would be silenced. They'd be convinced because the data is overwhelming.
Let me jump in here and take it a little bit in a direction for our audience. Dean Chemerinsky, this one's for you to start. As we just heard, you're a proponent of the idea that diversity in the classroom is a good thing, and that you both started talking about this, but let me put a little bit finer point on it. I think there's a real sense among those outside of academia, at least, that, and Professor Sander talked about this, that today's universities are not beacons of diverse thought, but rather more that a uniform sort of correct way of thinking has taken hold that skews far to the left. A lot of that has come out in opinions, at elite universities. The current climate is quite hostile to Israel. Jewish students report feeling anti-Semitism on levels not seen in generations. Question for you is, why shouldn't we as a Jewish community conclude that universities' efforts to find diversity in the classroom have failed and actually harmed us as a community? And why should we not be in favor of re-examining how diversity is being achieved, and if it is, whether we should even consider it a lofty goal?
There's a great deal there. To start where Professor Sander was, he says there aren't peer-reviewed journals. For those of you who aren't involved in law, which know, in law schools, journals are edited by law students. I've published over 200 articles in law reviews. I don't think that in law schools, law reviews are regarded as non-prestigious. Stanford Law Review is one of the most prestigious, and they published several articles showing that mismatch has no basis. In terms of Professor Lempert, is Professor Sander questioning Professor Lempert's impeccable credentials? If not, I think his review of the studies is very powerful. Next, you talk about diversity of thought. I think you tremendously overstate. There is diversity of thought in law schools. Most law schools have a very vibrant Federalist Society chapter. We have conservative and liberal professors. After all, Professor Sander is at a very liberal school and has been taking a very conservative position on affirmative action for 20 years. No one is silenced, Professor Sander, nor should they do so. So yes, I worry about peer pressure in the classroom. I worry about viewpoints being silenced, but I think we shouldn't overstate that either. Now, in terms of the relationship of that to affirmative action, I don't think there is a connection here. My point is that diversity in the classroom matters. Being Black in this society means you have very different experiences than being white in this society. In a classroom that's all or almost entirely white is a very different educational experience for everyone. And everyone benefits from having a diverse classroom. So what about the Jewish community? If you look behind me on my wall, I have written in Hebrew and English the words, justice, justice, thou shalt pursue. We can't be a just society if our institutions of higher education are almost entirely white. I'll go back to what the federal district court found as a matter of fact, that without affirmative action, Harvard would have only 6% Black students. 6% at a time we're talking about now. Or think about what happened at schools like UCLA and Berkeley after Prop 209 was passed, and there was complete absence of Black students in the years after 209. I remember teaching federal courts at UCLA in the spring of 2001. And students always came up to me and said, what's the difference from USC to UCLA? And I said, there's not a single Black student in this class. I had about 100 students in federal courts, and only a couple of Latinx students. And one of the students said to me, I'm a 3L about to graduate, and I've never been in a class with a Black student in my 3 years at UCLA Law School. There is a Jewish word for that, shanda. It's a shanda to think of having higher education that we don't have diversity. That's why affirmative action matters from a Jewish perspective.
Professor Sander, you want to address that?
Well, let's see. So let me share my screen on two things just to make correct a couple of, I think, factually incorrect points. So this screen is showing an analysis of how the composition of University of California freshmen changed from the year before Prop 209 went into effect to 20 years later. And what you can see is the percentage of UC California freshmen who were African American was 3.9% the year before Prop 209 went into effect. It was 4.8% in 2017. The proportion of Hispanics was 13.2% before Prop 209, 32.3% 20 years later. So those statements that diversity disappeared because of Prop 209 are inaccurate. If you look at oops, it's not letting me share my screen. Anyway, the other point I want to make is that the district court that Dean Chemerinsky cited did faithfully report what Harvard claimed, but ignored the report of Richard Cohenberg, who is the expert for the plaintiffs. And he did a very careful analysis that was not refuted by Harvard, that found that if you shifted the focus of Harvard's preferences away from race and towards socioeconomic disadvantage, in other words, if you did what the Supreme Court said and use race as a last resort instead of a first resort, the percentage of African Americans would fall from 13.6% now to 10.1%. The percentage of Hispanics would actually go up, and the percentage of disadvantaged students would go from being 75% underrepresented to being proportionally represented. So what you see in study after study is that under the current regime, where university administrators are under tremendous pressure to have sort of the right racial makeup of their classes, but they're under no pressure to take into account socioeconomic disadvantage. You see classes that class after class that sort of has this perfect racial balance, but is largely devoid of students who've grown up in poverty or working class environments.
And Professor Sander, just to interrupt you, sort of focusing in on the question about how Jews should be thinking about this, given the current climate, let's say in the university setting, should that affect how we think about the issue, or is it essentially irrelevant?
Yeah, I think
what Dean Chemerinsky is saying, I think.
Yeah, one of your colleagues at the outset of the discussion mentioned the idea of people, worrying about college admissions and the chances of their kids getting in. To me, that should not be an important consideration. In other words, students, white students and Asian students, I think are generally going to do fine in terms of what college they get into. I don't think that affirmative action causes students to get into bad schools because they're not a member of a favored racial group. The concern is really what it does to the atmosphere and what it does to the students that we're trying to benefit. What it does to the atmosphere is it establishes this principle that you're defined by your race. It fosters the identity politics that to me are a much greater threat to Americans in general, and probably Jewish Americans in particular, than these very ill-defined and unsuccessfully achieved diversity goals that Dean Chemerinsky has mentioned. We have this really terrible lack of intellectual diversity and no consideration by schools of how to really try to make sure that that minority views are articulated. I mean, I've had many Black students come to me over the years and say that they don't feel that they can articulate anything that deviates from the party line of BALSA, the Black Students Association, in their classrooms. They feel that they'll be ostracized if they do that. And it's impossible to really overstate the degree to which on controversial issue after controversial issue, you'll see complete silence in the law school classroom, even when professors try to bring out these viewpoints. And let me give you one more example that is very telling. There was a Georgetown law professor an untenured professor who said on a Zoom discussion that she did not realize was being recorded, how much anguish she went through from the fact that Blacks in her classes kept getting low grades. She didn't know that Georgetown uses really large preferences, and that the grade disparity had nothing to do with race. It just had to do with these overwhelming preferences the school was giving on the basis of race. But the school promptly fired her for simply saying that there was a problem, that there was a grade gap that she was concerned about. That sums up the whole idea. I mean, people in the academic community are afraid to even acknowledge that there's a performance difference now.
See, shaking your head vigorously, Dean Chemerinsky. Go ahead.
To start with, he misstates the facts. It was a lecturer teaching negotiation, not an assistant professor. She wasn't fired. She quit, albeit in response to very strong negative reactions to what she was saying. At least let's get the facts right. Now, the chart that you presented with regard to the University of California shows that you could come up with statistics to show things, but it's how you want to present it. I'd be really interested, as you asked me a question of what was the effect of Prop 209 5 years after it was adopted at UCLA and at Berkeley? And you know as well as I do that at both UCLA and Berkeley, it had a devastating effect on diversity. In fact, the University of California, in its brief it filed in the Fisher case, said it took it almost 20 years to get back to the level of diversity that it had before 1996. The district court, yes, you can pick the witnesses you like better, but the district court, as a matter of fact, found that the effect of eliminating affirmative action on Harvard would be quite devastating. Now, finally, I'm still perplexed about the relationship between affirmative action and diversity of thought. We both agree diversity of thought is enormously important. Would there be more diversity of thought without affirmative action? I don't see the relationship here. Is it that affirmative action isn't valuable because there isn't diversity of thought? That doesn't make sense, because the reality is experience does matter. Being Black in this society is a different experience than being white. I've taught criminal procedure in classes that are almost all white, in classes with a significant number of minority students. There's something very powerful when my Black and brown students talk about being stopped by the police just for driving while Black or driving while brown. That's not something that the white students can speak of. Diversity enhances the education of all students, and that's what the Supreme Court has said since Bakke in 1978.
Ariel, very quickly.
Go ahead.
Dean Chemerinsky says that there was a decline in diversity after Prop 209, but he hasn't looked at the UCLA experience. After Prop 209, we moved to a regime that considered socioeconomic status for the first time. And we had, the year after Prop 209, the most diverse class in our history. About 60% of the students were first-generation college students. Our school went from being about half of the students coming from the top 10% of the American socioeconomic distribution to about 60% coming from the bottom half. That had a dramatic impact on the classroom experience, because it was no longer sort of admitting upper middle class people of different races who all sort of very carefully articulated the PC views that they had imbibed. You actually had people who had a variety of backgrounds and really did bring different types of life experiences into the classroom. They weren't just repeating sort of the orthodoxies. Everyone knows that driving while Black is an issue, but to have a debate among different students about, well, has it gotten better over the last 20 years or has it gotten worse over the last 20 years? What's happened to police shootings over the last 20 years? What does the evidence show? Those kind of debates you never have in class because people are afraid to express their views. There's such an awareness that the racial diversity of the class is a carefully delicate manufactured product that everyone is afraid to even glancingly suggest anything other than the orthodoxy.
Professor Sander, I'll let you start on this one, but it's really a question for both of you. You're talking obviously to a Jewish audience that's only decades removed from these very same universities using quotas to limit the number of Jewish students admitted. I know, Professor Sander, you take the position that what's going on at Harvard for Asian Americans is really a quota, similar to what Harvard's treatment of Jewish applicants was in the 1930s. I know Dean Chemerinsky, you say it's not a quota. Who's right? And in light, for Dean Chemerinsky in particular, in light of rising anti-Asian hate and sentiment around the country, why should we be in favor of something that sounds on its face like anti-Asian American discrimination? But Professor Sander, why don't you go first this time?
Sure. It's possible to overdo the comparison between the treatment of Jewish Americans in the 30s and the treatment of Asian Americans in the 21st century. It's true, as I'm sure Dean Chemerinsky would argue, that part of the motivation for the current limitation on Asian American enrollment is to make more room for other students. And it's true that there's probably less anti-Asianism at Harvard today than there was anti-Semitism in the 1930s. But on the other hand, there are a lot of similarities. The origins of the Jewish quota were really driven by two things. One was that Jewish applicants were doing really well on the admissions test that Harvard used at the time, and they were heavily overrepresented relative to their numbers in American society. That's true of Asian Americans today. It was also the case that Harvard officials argued when they set up the quota and when they administered it, they talked a lot about personality and trying to get people of sort of the right character into Harvard. And that was clearly seen as something to disadvantage Jewish applicants. Well, Harvard today, instead of just using racial preferences, I think actually makes it worse by having this elaborate system where they use personal ratings. And the personal ratings are essentially, looking at what's your leadership potential, how well do you work in groups, what's your civic contribution potential, and it really came down. I think that was very clearly shown by the evidence to stereotyping against Asian Americans. Something striking that didn't come out of the trial at all is that Harvard even uses different standards within different Asian ethnicities. They don't treat Asians as a whole as a disadvantaged group. They have certain groups that are really disadvantaged, like Asian Indians and Pakistanis. Those who are moderately disadvantaged, like Korean Americans and Chinese Americans, and those who are treated more or less like whites, so Filipino Americans or Vietnamese Americans. So the degree to which Harvard gets into these extreme details of race and fetishizes it, I think is very disturbing.
Dean Chemerinsky.
Sure. First, Harvard is not engaged in having a quota. To my knowledge, college universities are not using quotas. In 1978, the Supreme Court held that quotas and set-asides are impermissible. The Supreme Court has never backed away from that. Now, Ariel, you said, I say it's not a quota. Professor Sanders says it is a quota. But what that leaves out as a formulation is that the district court, after a lengthy trial, hearing all of the evidence, concluded there was no quota by Harvard, that Harvard is compliant with Supreme Court decisions. That leaves out is the United States Court of Appeals for the First Circuit affirmed this as a matter of fact. Professor Sanders says, well, it can be overturned. It's clearly erroneous. That's a very hard legal standard to meet. And rarely has the Supreme Court ever overturned district court decisions by saying the fact finding was clearly erroneous. Second, you say, we're at a time of anti-Asian hate, which is unfortunately true. So we shouldn't have anti-Asian discrimination. I don't accept, nor does the district court accept, that what Harvard is doing is anti-Asian discrimination. That's why many Asian American groups filed briefs on the side of the Harvard plan. Asians are about 6% of the United States population, to over 20% of the Harvard students. Harvard gets about 35,000 applications for 1,600 slots. It has to come up with ways of evaluating students. And yes, it does involve looking to which groups are more disadvantaged than others and which need the benefits of affirmative action. That includes drawing lines among Asians, but that isn't the same as anti-Asian sentiment to give the monks from Laos a particular benefit is because of the need to do so in order to be able to achieve diversity. And so I just don't accept the premises of your question. And more importantly, neither did the Federal District Court or the United States Court of Appeals for the First Circuit.
Okay, I'm not going to give you a moment to respond, Professor Sander, because we're running out of time and I want to make sure we have a moment for people to ask questions. I want to end my questions to each of you by turning back to the title of the program, which is the Harvard's admissions case. What does it mean for us and our kids? I know, Professor Sander, you briefly commented on this, saying you don't think it means much, was what my takeaway. But Dean Chemerinsky, what do you think this audience should take away of what the case means for our children, our grandchildren, and so on? Dean Chemerinsky, that one's for you to start.
Oh, okay. I think the Harvard case is enormously important because it's about whether or not affirmative action will be able to continue in the United States. There is a long legacy of racial discrimination. A study by Christopher Jenks, a Harvard professor, a number of years ago, said that after empirical analysis that about 20% less is spent on the average Black child's elementary and secondary schools than the average white child's elementary and secondary schools. There's tremendous disparities to this day. What do we do about it? Do we shrug and say, well, we're going to accept a school that's almost all white? As the federal court found that Harvard would be only 6% Black without affirmative action? Or do we say, as the Supreme Court has said since 1978, diversity matters and that race can be used as one factor in admissions decisions? I believe that if ever we will be a society where we be colorblind, we still need to be color conscious in admissions decisions today.
Professor Sander.
So first of all, this PC bubble in which Dean Chemerinsky operates in the law school doesn't look at the facts. He's citing a study by Christopher Jenks that was done 2 generations ago about school spending. If you look at the school spending data today, you see that the average school with Black students receives funding comparable or higher to the median white student in something like 80% of our metropolitan areas. We've made tremendous progress in terms of equalizing school funding. There are severe injustices that we still need to address, but we have this environment in our colleges where we don't robustly discuss those issues because people are afraid of saying what's not PC. Again, I've had probably by now hundreds of people approach me over the years and talk about how much they want to discuss the issues that I've raised, which is just a small subset of the sort of issues that we ought to be concerned about, and feel that they can't because they feel that their environments are too hostile and they'll be harassed and punished. Ariel, you mentioned that I said this shouldn't be a big concern to our audience and their children. I think the case is tremendously important to everyone, but not because it's going to determine whether someone gets into Harvard or Williams or Duke. It's important because we have created this serious social problem through affirmative action policies that are now, they're such a sacred cow within the universities that the universities can't even afford to have them freely discussed. They can't afford to allow data to be released or to be publicly examined that shows what are the outcomes of students who come in with different levels of credentials. It's all suppressed. And there's been a dramatic increase in data suppression since I started working on this. And not 20 years ago, as Dean Chemerinsky says, but about 15 years ago. So issues in terms of the climate that our students are going to experience and what contributions universities are going to make to American society require that we have policies that are not dominated by this sort of internal orthodoxy that is very closely linked to policies that don't work.
Okay, thank you both. We've officially run out of time, but let's take a few more minutes if you'll indulge us for 5-10 minutes, if you have it. 5 minutes, Dean Chemerinsky is showing. All right, if you have a question, anybody in the audience, please type it in the chat. The question that I see there that was directed to me, and it's really for Professor Sander, just take a minute, is, and maybe Dean Chemerinsky, you'll have an answer, but what is the right way to get to diversity, Professor Sander? Or is it not something we should even be striving for?
Well, I think the right way is to use socioeconomic factors and to require transparency to make sure that none of the preferences we use have harmful effects upon students. The SFFA expert in the Harvard case clearly showed that you can have a win-win by giving more weight to SES. You would still have a great deal of racial diversity. Whites would make up a small majority of students, but not much more than half. And you'd have a class that actually had students from poor backgrounds and students from working class backgrounds instead of an overwhelmingly highly elite population that's there now.
Dean Chemerinsky, I see you shaking your head.
Sure. I favor diversity based on socioeconomic status. I'm the first in my family to ever go to college. Neither my parents nor brother, sister went to college. And I think people with those kinds of backgrounds do add something. But socioeconomic diversity doesn't achieve racial diversity. One of the things that UCLA and other universities found that when we use socioeconomic diversity, it didn't yield racial diversity. Why is that? A much higher percentage of Blacks and Latinx individuals are economically disadvantaged. But in numbers, the number of white individuals, much greater than the number of Black and Latinx individuals at disadvantage. So giving diversity on the basis of socioeconomic status gives you a much more white class. It doesn't yield racial diversity. That's why when I talked about what happened 5 years after 2009 and the tremendous decrease in Black and Latinx students, did Professor Sanders say, no, you're wrong, there was no decrease in Black and Latinx students at UCLA and Berkeley 5 years later? Of course he didn't, because there was. He said, but there was socioeconomic diversity. Socioeconomic diversity doesn't yield racial diversity. We need both in college universities, socioeconomic diversity, and we need racial diversity.
Okay, I'm with you.
You got one, you have one person out there. I don't see any other questions in the chat, and I know Dean Chemerinsky, you have to get going. So I'll wrap this up just by saying to everybody, first of all, thank you to our two distinguished panelists. Thank you both for the robust debate. We appreciate it and the time and the insights that you've offered. To all the people listening, I think the panelists would agree we've barely scratched the surface of these issues tonight. And both of them, if you go online, have any number of articles and publications out there that you can read and educate yourself to the extent you're interested. So Jeff, I'll kick it back to you, but thank you both, Dean Chemerinsky and Professor Sanders, so much.
Thank you.
Ariel, thank you so much. It was indeed a robust debate. Dean Chemerinsky, Professor Sander, thank you so much. And back to you, Sinai Temple President Mike Silverstein.
I just want to offer a hearty Mazal Tov to all three of you guys. I think you've enriched our community today, of which, by the way, many are attorneys, but the rest of the folks, including myself, are lay. And I think you've just made us a little more richer in our understanding and well-roundedness. So for that, I want to thank you both very much. Since you volunteered your time, I think this community also owes you a big point of thank you, because you make it possible for this community to learn from you, and for that we're very grateful. And Dean Chemerinsky, thank you for being a Sinai Temple scholar and resident in the past. I do remember that, as you mentioned earlier. If we were to have something in the future on a relevant topic, would any of you three, could we invite you guys back to be part of the Dream Team crew? Okay. With that being said, thank you so much, Ariel, for guiding discussion tonight. I realized that all three of you guys, I don't want to be in an argument with because I would lose. But for the right reasons, because you guys had facts on all points, and I think that was fantastic. To our audience of the Sinai Temple Men's Club, we want to invite you guys to renew your membership, to be part of our meetings coming up in person. For next month, just to let you know, Sinai Temple's own Andre Iancu, who served in the Trump administration as a patent attorney and intellectual property, will be in dialogue with our very own Jeff Kitchaven, discussing what it is to be a patent attorney. What are all the ins and outs that you need to understand to have that role in our administration? And by the way, as importantly, what is it like to be a Jewish person inside of the administration? So that'll be in the month of August, and those invites will go out. But with that being said,
Mike, if I may, Andre, just to elaborate a bit on his credential, he was Undersecretary of Commerce, nominated by the President and confirmed by the Senate. And he was the Undersecretary of Commerce and Commissioner of the Patent and Trademark Office, a position which was once held by Thomas Jefferson. So that's pretty heady stuff.
will we get Andre's face on one of the paper bills soon?
Who knows?
Okay, fair enough. With that being said, let me just bring it back to Ariel and Richard. Anything, we still have a few minutes before closing up. Anything from you guys to our audience tonight?
Ariel,
And,
you're muted.
yeah, there you go, Ariel.
Yeah, well, I guess Professor Sander, anything you want to add? Now that you have the floor.
Well, I don't want to be unfair to Dean Chemerinsky. Someone asked, what's the overall takeaway? I think it's that, people of goodwill can have very different views of affirmative action. And it's important to, the values that Dean Chemerinsky espouses, I think are all valid. The question is, how well has it worked? And, I tried to present some evidence as to why I think it hasn't worked well. And relatedly, and I can't emphasize this enough, the climate has changed in universities. So there's no longer the will to consider how well it's working. It's simply a forbidden topic. And that is incredibly disturbing.
And I think just a quote, I see in the chat, does equality to one mean unequal to another? Just looking back at a quote I had pulled from Dean Chemerinsky, who wrote that opinions on affirmative action have been shaped by whether the Equal Protection Clause is interpreted to require all people to be treated the same, or whether it should be understood as a guarantee of equal opportunity. And I think that's a very complicated legal question that none of us are going to answer tonight, but it does pose some thought of what is our goal and what is the goals of the Constitution when we think about these things. So
is it okay
food for thought.
Is it okay to ask a question before we adjourn? I guess not.
Yeah, sure, Marshall, bring it on.
Okay. I'm going to be blunt. Chemerinsky used just pure numbers in proportion to population. I question whether he would apply the same percentage to the starting lineup of every NFL and every NBA team. I think he's in his own bubble in university, and he has this idea, and we have lawyers here, that it's great to be a lawyer, and if you're not a lawyer, you're really deprived. Now, we have some great lawyers on the screen. Not everyone is as great as the lawyer on the screen. If you look at the numbers, I think the lawyer's average makes $125,000 a year. Sounds like a lot, but you professors know how much debt lawyers have. And maybe some of the Black people are smarter than you are. Maybe they want to be something more important than a lawyer, like a client. Do you think that LeBron applied to law school and was turned down, and therefore he had to play? Do you think that Oprah applied to law school and she was turned down, and therefore she had to be a media mogul? I think he's just limiting his focus on law school with the false premise that it's the greatest thing in the world to be a lawyer, and if you can't be a lawyer, you're being persecuted.
Well, I think that the focus of the discussion was around this college admissions case, and so that's why the focus was there tonight. So to be fair to Dean Chemerinsky, I think that's what we were focused on tonight.
Well, yeah, and I would just add, I think that the equity, the proportional representation is a fine goal, and it's a good benchmark against which to measure progress in many ways. The demand for a law school among African Americans is comparable to the demand among whites. To give an example closer to the Harvard situation, Blacks are somewhat more likely than whites when they're high school seniors to want to become scientists. But the problem is that if you're admitted to Harvard, for example, and you want to be a chemist, and you get a very large preference, that makes it very hard for you to succeed as a chemical student at Harvard. You're going up against students who have higher test scores and probably more extensive high school training in the area. So there have been 3 studies now that have shown very high attrition from the sciences at schools like Harvard among Blacks or Hispanics who receive large preferences. Again, it's not a question of race, it's a question of under what standard you're admitted. And so that becomes self-defeating to the equity goal. You know, you're not achieving either the equity that you want or the equality of opportunity. I think if you have very large preferences, you lose on both fronts. That's why I find these policies so frustrating. Anyway, enough of my monologue. I appreciate you all coming, and and Ariel, the questions were great, and I thought it was a very good discussion.
Thank you, Professor Sander. We appreciate your time and your insights.
Thank you all.
Thank you very much tonight. Thank you, gentlemen. I wish
All right.
everybody a wonderful evening.
You as well. Take care.
Looking forward to next time.
Thank you. Good night.
Good night now.
Michael, thank you.
You got
Great
it.
Presentation.
You got it.
Good to see you all. Good to see you, Jeff.
Thank
Michael.
you, Ellie.
Yeah.
Good to see you.
And thanks for that reference.